we met to talk about the panel this morning, we broke it down as follows. Lee was interested in talking about some big picture issues. I'm going to talk generally about the perspective on competing access or juggling competing interests in land from a farmer and rancher perspective. And then the other Peter will talk about some examples for land use specifically and where things are working and where there might be some challenges. So I wanted to start out by saying that this is my second Synergy conference, and I'm delighted to be here. It's my first chance to talk to the group as a whole, and I wanted to let you know that I am handling Synergy in kind of the reverse order. This is very similar to the way that I got involved in 4-H. My kids grew up on our farm, but I got involved in 4-H in reverse order. My first involvement was actually as a director on the 4-H Foundation. I worked my way down from that, all the way down through a leader of our 4-H club. Then I was an assistant leader. We had someone who left. Then I was a group leader for a woodworking group for 3 years, where I had kids come out to our workshop and build things and show their fingers at the end of the year. They had all 10 fingers. And finally, I was a speaker judge and a parent volunteer, and now I just go and watch. So it's the same thing here. I have never been part of a Synergy group, but I've started on the board of directors. And as Farmers Advocate, historically, the Farmers Advocate has been on the board of directors of Synergy as a result of the Office of Farmers Advocate and to maintain a link between the Department of Agriculture and Rural Development and Synergy. So I'm starting at the board, and ultimately what I hope to do is join a Synergy group in our area and then not go to meetings. I think that that's going to be the flow of things. As Rick mentioned, I've been the Farmers Advocate since April of 2012. I haven't met many of you outside of the Synergy context, but most of you know one of our team members. Carol Goodfellow is here this morning, and Carol, if you would stand up. I know that most of the members, hi Carol, most of you have either heard Carol talk, seen her present, or heard of Carol. Carol's role as part of the Farmers Advocate Office is handling the land and energy file. So Carol has always been involved in dealing with land and energy issues and trying to help inform the debate, first of all, for farmers and ranchers as to what is the box that they're playing in? What are their rights and responsibilities with respect to land use? What happens in Carol's role is that she does really three things. Number one, she provides information to farmers and ranchers when they contact our office, look at our website, or look at our publications about the box or the sandbox that they're playing in. Often what we see and what Carol sees is, for the first time in their life or in many years, a farmer or rancher will be approached by an oil and gas company, a landman, and brought a proposition that they are asked to deal with an issue on surface rights. And many times, farmers and ranchers have been very successful in running their cattle operation, running their farming operation. They haven't spent a lot of time learning about surface rights. So they need to start to educate themselves, and many times they come to Carol to do that. As part of that role, providing information, Carol and our office does an awful lot of outreach. We go to many different groups and organizations, and in the past year and a half, Carol has spent a great deal of time on the road going to ag service boards throughout the province and providing information to the ag service board members and their invitees as to what is going on in the world of surface rights, land use, land and energy as it relates to farmers and ranchers. What can they expect, and how do they start to address it? So information, outreach, and then Carol and our office also provides advice to farmers and ranchers and advocacy on specific files. So we don't stop at the point of providing information. We don't stop at the point of doing outreach and doing presentations. In cases where it's necessary, we will help you, advocate with you to get the information you need. We won't simply say, if you call Carol, she won't say, here's the rules, here's a website you can go to, good luck with that. If you want our help or her help, we'll actually help you set up meetings. We'll help you get some of the information you need with respect to pricing issues for your area. And so part of our role and the luxury that we have is that we're in a position where, as Lee has said about his office, we're not a regulator either, we're advocates. And so an important part of what we do and what we are focusing on, at least as much more of a priority in the past year and a half since I've been in office, is actual advocacy on files. I've essentially loosened the reins on the team and asked them to participate actively with farmers and ranchers when they need help. So we don't represent people in litigation much the same way that Lee talks about his office, but what we will do is we will come to a meeting with you, we will come to a synergy group, we will come and meet with farmers and ranchers, and we will help navigate the process and we'll help sweep the road. We can't change the rules, but we can certainly help you through the process as opposed to simply learning about the process. And it's really been a privilege for me to work with a team that includes Carol. It also includes Graham Gilchrist. And Graham used to work with our office. Graham, if you can stand up and wave. I'm sure most of the people here know you as well. Graham was assistant farmers advocate for many years and has left us. Lee has scooped him, and Graham now works as the assistant property rights advocate. But as part of the delicate dance of negotiations that we had, we were fortunate enough to get Lee and the Department of Justice to agree that Graham would be housed on the third floor of the J.G. O'Donoghue building, kitty corner from our office. So while Graham has left us, he hasn't gone too far. And I wanted to introduce Graham and mention that point to underline the working relationship that the Farmers Advocate Office has with the Property Rights Advocate Office. One of the questions that sometimes comes up is, what are the roles, what are the responsibilities, what's the division? And that is something that Lee and I talked about right after Lee took the position, is how can we best use our very limited, extremely efficiently used financial resources to meet the needs of our offices. And so we have essentially agreed to work together regularly to make sure that there isn't a bunch of overlap. And from a big picture perspective, the roles are divided along the following lines. The Farmers Advocate Office restricts our information and advocacy to farm and ranch issues. So if you're an acreage owner and you're really upset about trees, we're not likely to help you. We have limited resources. We work for farmers and ranchers, and we tend to get involved in the advocacy and the proactive side before decisions are made, before a regulator has made a decision that affects a farmer and rancher. The Property Rights Advocate Office does a lot of information provision as well. However, if an issue comes up for them where it relates to a farmer and rancher, they will often suggest that the farmer or rancher contact us so we can assist them with advocacy before a decision is made. And where Lee and Graham get involved in is assisting farmers and ranchers and other Albertans with dealing with the process after a decision has been made, especially in cases where there's been a compensable taking, some sort of expropriation. So we do work together closely. We've divided things up to make sure that there is a lack of duplication and an efficient use of services, and it's been a real privilege to leave some of the hard stuff to Lee. I wanted to start though, and I've been, I think, at every session, public session so far, and nobody started with a joke. And so there are two lawyers on the board, and I thought I would start with a joke I've used for many years that the farmers and ranchers probably know. And my question to you is, how many lawyers does it take to grease a combine? And the answer is, well, just one, but you got to feed them through real slow. So I say that because, again, from time to time, it's lawyers who get a bit of a bad rap. And currently, if you listen to Lee's serious comments, there's a big fundamental issue going on with respect to property rights. And in my view, the topic today, juggling competing interests in land, I thought was really aptly phrased. What we read about in many publications is balancing competing interests for land. And I thought it was interesting that the panel was actually described as juggling competing interests, because I think that that's what we do as landowners. Farmers and ranchers are really, in many ways, not given the luxury of balancing interests. We're really juggling the various competing interests for land. And so as farmers and ranchers, we do a number of things. We decide what crops we're going to seed. We take a short, medium, and long-term look with respect to our farming operation. Are we going to buy more land? What's our crop rotation going to be? How can we best manage activities on our land for the short, medium, and long term, so our kids and our grandkids, if we don't like them, then they could take over the farm and have an opportunity to continue. So landowners, farmers and ranchers in particular, are really juggling competing interests. And it's been my observation that what happens is that most of what farmers and ranchers run into is really a reactive situation. Farmers and ranchers are in the business of farming and ranching, and generally speaking, are not in the business of generating revenue from granting interest in their land for pipelines, other rights of way, and surface rights activities. That's a reaction to a request that's generally made to them. And so farmers and ranchers spend a lot of time and energy learning about their business, how to manage it, how to run the farming and ranching, how to manage club root, how do we deal with that, okay, where do I invest? And then they are approached, in many cases, by a landman, a municipality, a neighbor, some other user or interested user in the property, and they're required to stop what they're doing, spend some time and energy learning about the request, and then trying to decide how to respond. And so the juggling term, I think, is really apt from the perspective of what farmers and ranchers are required to do. And the world changed, I think, for most of us, although you may not know it, in 2006. In 2006, the Supreme Court of Canada made a ruling on a case called CPR and Vancouver. And what happened was, in Vancouver, the Olympics were coming, but the CPR had a bunch of railway right-of-way land that they owned, and they didn't want to run the railways anymore, and they thought they would sell that land to the city of Vancouver so that the city could use it for whatever it wanted. What the city of Vancouver, in its wisdom, chose to do was not accept the offer to purchase or to make an offer to purchase, to buy the land. What they did was they re-regulated the land and said in their land use bylaw or rezoning that the only use for that corridor could be essentially a transportation and tourism type corridor. So they sterilized the other uses of the land. The CPR could not convert that land into construction for residential or commercial or industrial activity. And the CPR argued that this was really an expropriation of their interest in land, that the city of Vancouver had, by re-regulating, rezoning the land, essentially stripped CPR as owner of all of its rights of alienation or ability to sell the land or deal with it. And that the step taken by the city of Vancouver was so broad that it was equivalent to an expropriation. The Supreme Court ultimately ruled, however, looking carefully at the common law, the BNA Act, the legislation in Canada, that in fact this type of regulatory taking without compensation was permitted in the Canadian context. And that was a Supreme Court decision that's binding throughout Canada, and that's a bit of a shock to most of us. I think we had a sense that an expropriation or effective expropriation really would result in some compensation to us. We may not be happy about the fact that a government was taking our land for a government purpose, but we would be compensated based upon our understanding of the Expropriation Act in the province. So that doesn't happen. And I raise that issue because in 2006, a few other things were happening in the province of Alberta. The oil and gas, particularly the gas sector, was going crazy. Gas prices were high. And in the Vegreville, County of Minburn area, for many years, we had been safely insulated from the boom. We did not have any oil and gas activity, but all of a sudden, 2004, 2005, 2006, there were gas rigs everywhere, wells going up. And so for the first time in our area, we had landowners that were encountering these requests for access to land and starting to learn about what they had to do. So 2006, a couple of things happened. Also, the economy in Alberta, as we heard yesterday, started to really grow again. And the population started to grow, cities and towns expanded. So in addition to these requests for access to land for oil and gas activities, many of us, and many of our friends and neighbors as farmers and ranchers, were encountering challenges in operating their activities on their farms because the towns and cities were growing. So we were in the same spot. Judy's farm stayed where it was, but a new subdivision came in, and all of a sudden we had neighbors that we had to deal with. And we started to see in a broader use of land use bylaw regulation by counties and by municipalities to control operations within their zones. So the balancing or juggling of competing interests started to become a little harder, I think, for farmers and ranchers. We were forced to deal with a number of things, surface rights requests, and also re-regulation at the municipal level. Our experience in the office of the Farmers Advocate is that farmers and ranchers are very concerned about needing to understand what the rules are. And so my question last night to the Alberta Energy Regulator is, help us understand what the rules are going to be for farmers and ranchers. We may not be happy with those rules, but once we understand them, farmers and ranchers can cope with them, A, and B, work to improve them in cases where things aren't going as well as they should. So if you ask Carol, what type of things does she hear from landowners, from farmers and ranchers in Alberta about the new rules in place with the Alberta Energy Regulator, it's very clear to Carol and to us that the message from landowners is sufficiency, adequacy of notice on applications is something that is very important to farmers and ranchers and that needs to be as broadly defined as possible. So for example, the historical situation has been that as a landowner, you're given notice of a proposed application on land that you own or occupy. Your neighbors may or may not become aware of it. There's a general appetite out there among farmers and ranchers for broader notice, so at least contiguous quarter sections. So if there's an activity on Iris's quarter section where it's way away from where she lives, she doesn't care really as much, doesn't affect her sight lines, or, the noise doesn't affect her, but the activities on that quarter will significantly or possibly significantly affect her neighbors. They should be given notice early on so that they can self-identify as directly and possibly adversely affected. And so we are working to try to deal with that issue. In the final minute, I guess I will just emphasize that in terms of trying to balance the competing interests, our role at the Farmers Advocate Office is advocating the best process possible within the box of the regulations. And so to that end, we've heard, and we are conveying back to our minister and to other ministers and to other people within the government of Alberta that notice, proper notice, is vital. And the reason it's vital is that it's impossible as a farmer and rancher to juggle a ball that you can't see, that no one has handed to you, and you don't know its size. And so in terms of trying to juggle these competing interests, what really our job is as the Farmers Advocate Office is trying to make the fight a bit fairer. Landowners, surface rights owners, and mines and minerals owners really are in a bit of an unfair fight because they don't have the expertise, the knowledge. Our job is to try to make it a bit more of a fair fight and A, try to teach you how to juggle, and B, limit the number of balls that are in the air. So that's what we're working on, and part of what I'm hoping to get today is questions that will give us some examples that we can take back to the province as to how we can address those concerns. Thank you very much.